tangible items where family heirlooms and stuff have been specifically handed to specific people before the person dies, then in that case, those things aren't an issue so much in the estate, and the estate can focus on more important things. I think that's a great practice. I encourage it to all of you. You don't wait to die to give away heirlooms. You give away heirlooms before you die. It just simplifies things and heads off what could be generating animosity for years.
Welcome to Life's Third Act, an enlightening look at estate planning, retirement, and beyond.
Welcome to another episode of Life's Third Act. We're coming to a part two to the first part, which was several weeks ago. I encourage you, those who have not watched part one of the Lizzie Borden story that we've done, I think you'll find it very interesting. And of course, it informs what we're going to talk about today in part two. But Lizzie Borden is pretty much almost a cultural icon in some ways because of the shocking, brutal murder that took place, the idea that a woman was tried for it, the fact that she was found not guilty, and questions about the way the trial was conducted, presumptions that women had when they were accused of such violence at that time. I mean, these were axe murders. So there's lots of controversy associated with the trial and the whole series of events. And with today, we wanted to pick up, though, at a place beyond which many don't go when they talk about her story. They go through the time that there was a trial in which she was found not guilty, but they don't pick up much with what happened thereafter. And if they do, it's just the general terms that she lived out the rest of her life, she and her sister, Emma, and that they both died in the 20s. So we wanted to add a little more information to that, and with a little more focus on what the arrangement was with her will and how that ultimately played out. So in a way, while there's much more interest in part one in some ways, I would argue that part two is less familiar to many of you who have some knowledge of these events. So let me pause here first to remind you all that Cordell & Cordell is a family law firm, and in addition to domestic relations, we practice estate planning. So we don't have estate planning lawyers in all of our offices. We have them in a number of our offices, and there's a good chance that in your area, we have one of our attorneys that practices in this area. So I encourage you, if you haven't done your estate planning, if you watch this show, you know how important it is. So I encourage you, give us a call, and we'd love to help you plan for, you could argue, among the most important things in your life are to take care of not only yourself, but those who you care about in this world. So with that, we'll go ahead and get started. We left off with the estate, the outcome of the estate with Lizzie Borden, the fact that there was no will, so the assets were divided between her and her sister Emma, that was kind of the intestate succession laws of the time, that there were some very interesting questions about things such as simultaneous death, where there might have been a question as which of the parents died first and what were the implications of that, and they could have been substantial, but at the time there weren't laws that now are universal in the United States, and that relates to presumptions when you have people where it's not clear who died first, and often that's a scenario involving a husband and wife, and these can be hugely important issues. So let's move forward. Lizzie, not surprisingly, with some money to spend and the ability to live a lifestyle that she would not otherwise have enjoyed with her fairly puritanical, and I don't mean that as a pejorative, with her strict father who was frugal. And he believed in living not quite a Spartan life, but a life without frills. And so it was well known in this community that this family was wealthy. Still, the father, the patriarch, he wasn't going to spend any money on anything that was unnecessary, certainly not luxuries and whatnot. So they went from that to inheriting. Essentially, there was $300,000 at the time, which you have to appreciate in today's dollars is at least $10 million, if you think about what that buys in that era. So this is divided between Lizzie and her sister Emma. Emma's about 9 years older than Lizzie. They end up living together for a while. They buy this house, Maplecroft, beautiful home. The home has 7 bedrooms, 3.5, I think, baths, 3 or 4 baths. So this is unusual at the time. This was a mansion. So they live what happily it would appear, except that to some extent, Lizzie suffered some ostracism in this community, which is not surprising. Many of the women were quick to conclude that she was guilty, whereas the men had tended to give her the benefit of the doubt. So it was the women that had the ability to impose these sort of strictures on her socially and to exact a price more so than the men. And these were the people who I think were determined to exclude her to some extent. She did continue to be involved in her church. Believe it or not, she taught a Sunday school class. I don't know how long she continued to do that afterwards. She did, though, decide that she was going to enjoy life much more. She spent a lot of time in Boston, New York, Washington, going to plays. She loved theater. And these are things she wasn't afforded the opportunity to do previously. So apparently she was cultivated to some extent, and yet she had not previously had the opportunity to enjoy those interests. And so she took full advantage after 1892, after 1893, when she was found not guilty. Thereafter, she started traveling more to these cities particularly. She would shop there. She would come to know some of the theater people. And this became her social life. And it's kind of understandable, when you think about the doors that were closed to her, closer to home. So she ends up meeting this woman, and this is a very interesting piece of the story after her trial, was that she started going to these theaters and whatnot, and she met someone by the name of Nance O'Neil. Now, this is an American stage actress. She'd actually been in a few films. I've not looked those up. I'd be curious what films. You think we can bring up and put some pictures up of this person known as Gertrude Lamson? Yeah, Gertrude Lamson was maybe the American stage name. Anyway, the name that she was known by when she was met with Lizzie was Nance O'Neil. And Nance O'Neil was in a number of shows, and I assume an actress of some renown. So they developed this relationship, and this relationship became more than just a friendship. So we have this couple these two sisters who they lived together their whole lives. One is accused of murdering their parents, found not guilty. So the two move into a house together thereafter. I think I'd said in the first show that they had that Emma had gone her separate ways very quickly, that Emma seemed to take the proper family line or the loyal line to her sister and defend her sister, but after the trial that she spun away. That really wasn't the way it happened, actually. I've since done some additional research, and it appears that they did end up in an estrangement that lasts the rest of their lives. But it didn't happen until 1905. So prior to that, they lived together, and it appeared that both names were on the house. The reports that I'd read said that they had bought this house, and they lived there together until finally we have Emma, who's becoming unhappy with these parties. She doesn't want anything to do with these theater people. I can understand that maybe. So she just, and the relationship, let's not forget that Liz was having with this actress. So at that point, the estrangement begins. She leaves the house. She eventually lives in New Hampshire. So they talked only a few times thereafter. That was the estrangement. So from 93, we'll say, was in June of 93, that was when the trial was, and the house was bought toward the end of that year. So we had a full year, maybe a year and a half, in which they lived together in that house. But I'm not seeing where Emma was paid for her share of the house. And we know that Emma would not have simply walked away from that money, so I'm not suggesting that. But I am suggesting that maybe Emma wasn't on the deed at all, that the sisters concluded that, and I could see this, where if it was really important to Lizzie to own a house that she really liked, a mansion, she would say, I'm willing to pay for it. You can pay me while you're living there, and that way you don't have to spend any of your money on it. You can see how that would be attractive to both of them. We just know that she did move away, and that at that point we have Lizzie continuing her relationship with the theater friends, but soon this thing with Nance kind of hit the rocks, and they didn't communicate anymore. I'm suspecting that something was going on maybe with Nance's health. So they were close, and they were close for quite a period of time. But you can imagine that an actress in that era would not have been inclined to have roots, is my guess. And one thing about Lizzie had roots. She wanted to stay in that town. She wanted to stay in that house, and she stayed there virtually until she died. In fact, she died in that house. So let's move along here. She dies in 1927. She's 60 years old, which oddly, her sister dies like 4 days later, at most 5 days later. It's shocking this improbability. Her sister was living in New Hampshire at the time. Lizzie had problems that they thought was her gallbladder. She'd gone to a hospital in Providence. She had been there for some time. I'm getting the sense she was there for more than a month. There were comments by the staff that this woman who had an alias, at least it wasn't Lizzie Borden, it was a similar name she used, but she was a problem patient. Anyway, she died. Her sister died. She did have a will, unlike her father. She had a will. And interesting enough, the will that was drafted for her was drafted by the same attorney that had represented her family, including her father and mother, prior to their deaths. And this was a Charles C. Cook. So Charles C. Cook, this family attorney who stayed on through all of this, he stayed on, and apparently Liz trusted him. So if you do the math, you can think, well, this guy must be pretty old, and he was. I think he was in upper 70s at this time. So he was the executor at the time she died. He also was a beneficiary, a major beneficiary, which I can tell you it's uncomfortable for a lawyer to be a major beneficiary if they're doing the drafting. As a matter of fact, I don't want to say it's per se unethical, but I would say that the rules of ethics would suggest, if not require, that you, an attorney in such a position, hand over the preparation of the documents to someone else, that they can't name themselves as a beneficiary unless they take extraordinary steps to make it clear that there was no undue influence or manipulation, et cetera, because of this sacred relationship. It's a fiduciary relationship, and that would just be shocking today to see that, unless somebody else had prepared it. And apparently, Charles Cook prepared it, and he named himself as executor. Now, I'm not suggesting there was any manipulation here. By all appearances, as we've discussed, I don't think Lizzie was somebody who was going to be easily manipulated. I think she was a person of strong opinions, and she made this decision. So that's the way the document was drafted. Except interestingly enough, you would think that a person who was a lawyer who is drafting a will in which they are a beneficiary would not fail to be sufficiently precise in the language to assure that there's no confusion in probate later as to whether they're to get some of those assets. Well, maybe Charles, at the time he drafted this, wasn't at his best anymore. One could argue that maybe he never was quite at the level he should have been. We don't know how good a lawyer he was in his early days. We know that her father did quite well in investments and whatnot. We know that Liz did quite well. And more about that in a moment. But anyway, Charles drafts this document, and he leaves vague who exactly was to get this house. So Maplecroft is one of the largest assets in the estate. It may have been the largest. I didn't see a breakout on. I saw the total numbers, but not breakout of individual components as to what each is worth. But clearly one of the most valuable assets in the estate. And even though there was a reference to specific things going to Cook and some language about generally she wanted him to get the bulk of her estate. And I don't know how precise. I couldn't get a copy of the will. I tried to get a copy of it, apparently, because things were archived so long ago that it's difficult to get a copy of that today. So we don't have it. But anyway, that we now have what we need to know. And that's that Cook names himself, and then he's acting, of course, as executor of the estate. Remember, the role of that person is to sort of shepherd things through to assure that the right debtors get paid, or those who have claims on the estate, and then that the assets end up in the hands of who they should. And so that's sort of the marshaling process that an executor has to do in order to close the estate. Well, it seems that this estate wouldn't close for 6 years because there was a dispute about where some of these assets were to go. When you prepare a will, you'll often make what you call specific bequests, and these are line item things where this asset specifically goes to this person. So that's often in what might be termed the body of the will, and the main body of the will. And then you have the residuary portion of the will, and the residuary, as the word residual means, it just means that what's left. Well, sometimes there will be very little in those upper paragraphs in which someone will say, I want this asset to go to this person or that to that. Sometimes people will have virtually nothing there, and you can imagine where this would not be uncommon, where tangible items, where family heirlooms and stuff have been specifically handed to specific people before the person dies, then in that case, those things aren't an issue so much in the estate, and the estate can focus on more important things. I think that's a great practice. I encourage it to all of you. Certainly our family does it, and that's where you get older. You don't wait to die to give away heirlooms. You give away heirlooms before you die. It just simplifies things and heads off what could be, generating animosity for years because of disputes over these things. So in this case, or in some cases, what will happen is that will occur, and then those specific items are out of the way. And then so you kind of go specifically from the statement of the will, the statement of the beneficiaries, and then you go to the residuary clause where you essentially say, and everything else I want to go to these particular beneficiaries. So it's a very often all of the interest that you have in a will exist in that last paragraph. Everything is covered there. And you can see how it would be very common because you often will take all of your assets, for example, and give them, if you have 2 children, 50% to one or 50% to another, or other limited number of people in your life that you want to treat similarly. And so that's best done through a residuary clause, meaning a residual sounds like this is kind of what's left, as if it's of less importance. Oddly enough, the residuary clause is often what's most important, and in fact can be everything can be covered there. Well, in this case, the way this was drafted was there were specific items. Even the real estate was referenced in the body above the residuary clause, and creating the impression that the intention was to give it to Cook, who had been named as the beneficiary of various items, and some of it included properties. There were some lots that were owned in the town, some real estate that still were owned from her dad having owned it. So we know that there was a mixture of stuff, but we know that the Maplecroft property was most important. We've seen references to, there's also bank stock, of course, furniture, jewelry. Apparently none of that stuff had been given away before. And there were some expensive items of jewelry that were bought after the death of the parents. And so then we have the furniture, and we have a sum, though, that adds up to apparently, I've seen two different numbers. The number that I think is most reliable is around $275K. I've seen a previous reference to it was above 175, but it sounds like that's just naming a threshold for state purposes in terms of, probate tax or for some other local state purpose. But I think the value is closer to 275. And if you think, even though, granted, this is 40 years later, or less than 40, 30 years later, that this estate has had time to deal with inflation and whatnot. So you have a little bit of difference in purchasing power during that period of time, granted. But still, to go from what was around 175 before, which was 150 to 175 is what each of them got out of this $300,000 estate, to move it to, as she did, we'll call it the 275. I mean, that's handling money pretty well. It shows that the investments that she had did well. Probably the bank stock, probably these other lots appreciate in value. Apparently Maplecroft, it looked like a beautiful home. That probably appreciated significantly during a 30-plus year period of time. So all in all, I think that she managed money well, and I think that she didn't really, of course, have people in her life that were the natural recipients, of her estate. So it ends up being this Charles C. Cook. He gets a substantial portion, and then she has in the residuary provisions that last section would be either Grace Hartley Howe, which was a cousin of hers, and also a longtime friend, Helen Layton. Now, I don't know much about these two people. I know that they must have been very loyal to her over her life. These were people who stood by her in this community. So she was determined to give them something substantial. So what ended up accounting for a 6-year probate battle was entirely this Maplecroft home. So just because of the vagueness of the language, which I put on the shoulders of Charles C. Cook, he ends up being pulled into 6 years of litigation, of expenses and whatnot, much of which is paid through the estate, incidentally. But still, he and these two residuary beneficiaries have to wage this battle. But the court ended up concluding in the early 30s was when I guess the gavel finally went down on this, that no, it was not, the real estate was not intended to go specifically to Charles Cook. There was some vagueness in the language, but that because it wasn't made clear, then it falls into, by default, this would be the law today, if there's ambiguity about a specific grant above the line, then it would fall below the line to the residuary clause. And the residuary provisions, of course, everything went between these two ladies. So it was a battle that I guess they felt it was worth it. I mean, geez, what's the value? Imagine the value of a home like that in dollars in that day. Especially, we know that oppression came on not long thereafter. So at the time this started, the 20s were still roaring, but the roar kind of faded away by, late 29? Anyway, so the way this fell was that the assets were distributed to two friends that she cared about, and then we have Cook, who he died shortly thereafter, oddly enough. He lived through the litigation, then he died, I think, 2 years later. She made some charitable gifts, philanthropic. Apparently she was interested in animals. I didn't read about her owning animals, but surely she did. She gave $30,000. Now, remember, that's probably, I don't know.
There was that pigeon story when she was young, so maybe that had something to do with it.
Oh, the pigeon story where her dad killed the pigeon.
Her birds.
Yeah, she was really into birds. And I did read though. I take that back earlier because she continued to have an interest in birds, and she had birds in her house. And I assume that's in cages, but who knows?
One would hope.
Yeah. So she spent times in her garden and with her birds. I remember that reference to how she spent her time later at Maplecroft. So $30,000 would be, I don't know, at least $500,000. It's a big number today, and this was left to Animal Rescue League, smaller cash gifts to Animal Rescue League in Washington D.C., chauffeur's family, servants, and then maintenance funds for her father's cemetery lot. So what can we say? Wrapping up here, she handled her state better than her dad. She took the trouble to have a will. A trust would have been better. Some of these things would have been headed off because trust, brings these to the present so that they're typically dealt with earlier. And if they're not, they typically are regarded as resolved later by courts. They're impatient with people raising new complaints with trusts. So in this case, I think that she did the basics for somebody who didn't have children. She did plan, which some people would say, I don't care what happens to my stuff afterwards, but she did have some people in the world she cared about. So I hope that this episode has been interesting to you. I hope that you learned something as well, and I hope that you tune back in for this show. This has been Life's Third Act. Until next time, take care.
We hope you enjoyed Life's Third Act, sponsored by Cordell & Cordell, your advisors for estate planning and beyond. Subscribe and join us weekly for thought-provoking discussion and topics exclusively focused on estate planning and your financial future. Discover more at CordellCordell.com. The choice of a lawyer is an important decision and should not be based solely on advertisements.